you. I got through that quicker than I had planned, which is good because I've left time for questions, which is the plan. So I'm happy to field your questions, and there are microphones here. Questions or observations?
Thank you very much for that speech and for those numbers. That's fantastic. Just wanted to clarify with the numbers of the ones who opposed the amendments. Does that include people who supported some kind of amendment but opposed the proposal?
I don't know, and I'd like to find out. The document I was given under Freedom of Information is a table where the Attorney General's Department has listed all the submitters by name, and that's been blanked out, so I don't know who they are. So the first column is 1 down to 4,100 something. Then there's the names that are blanked out, and then they've got columns with ticks. There's a column that says yes with ticks, and a column that says no with ticks, and a column that says opposed with ticks. Repeal with ticks. And then there's another column which tells you whether or not there were comments attached to the thing. So it's a very shallow little numbers. Any depth, I'll have to go back and seek further documents.
Can I just ask, what will you do with those numbers and the article?
What are you going to do
and
with
the article?
them?
Well, don't you worry, I'll be using those numbers tonight to write to the Prime Minister and Mr Brandis, as I've done in those submissions.
Good, okay.
But,
yeah. So now, look, the numbers are there to inform the debate. I mean, I think that they are they anticipate, well, I thought they anticipated, but in fact, Senator Brandis has already asserted that he has support, so they cast some doubt over that.
Yes.
Thank you, Simon. That was very productive and intelligent. Wonderful to listen to, as usual. I had a question about other attributes. So you talked a lot about race and racial vilification and racial discrimination. And I was talking to someone about a consolidation project recently, and they were quite horrified at the idea that the Race Discrimination Act would be brought in with the other attributes like disability and age, for example. And it got me thinking also about the way that race seems to be singled out in international human rights law as particularly deserving of protection in relation to racist hate speech. And I wondered whether you had a view on whether it did have some kind of special status amongst the attributes that we talk about. Is racist hate speech worse than homophobic hate speech? Is the level of harm greater?
Well, as you know, the formal position in international human rights law is that there's no hierarchy of rights. And I think we could extend from that there's no hierarchy of attributes that are protected by rights. That's not to say that, I mean, that's the formal legal position. But some of you would know my colleague Neil Rees, who, if you're missing him from Melbourne, he's now on the Sunshine Coast. And Neil has, and he's put this in writing so I can quote him, a provocative position that race and sex as attributes are deserving of particular attention, and that other attributes may not have the same standing. And he does that by reference to the world we live in. And a different society may say it differently, but race having its status as it does in international human rights coming out of the Second World War, and that's really its source, and sex because of the just in-your-face inversion of women's position in society, loom large in our society. So Neil's position that no one else has taken up is special status. My view is that that's an unrewarding path to go down. I mean, it's just an invidious debate to once you start getting into the hierarchies. That's that point. But how much of what I say about racial vilification could be said about vilification on the basis of gender disability agency? Because it happens, and there are very quite vocal campaigns for recognition of what undoubtedly happens. People are vilified because of their age. We see it when it happens. I think a great deal of what I've said is the same. If we're talking about the doing of harm, if we're talking about people who are unhappy in their life, who live their life being old and getting bagged for it, then I think we're talking about the same kind of thing. Now, yes, it's very hard to say that and then not address the question of, well, how many attributes are you going to add to it? Okay, I'm avoiding that. I just don't know when you stop. Because Victoria, you may know, is the only jurisdiction in Australia that prevents discrimination, and therefore possibly one day vilification on the grounds of physical features. And that is taken by some as an example of, well, how far are you going to go with this question? So I think vilification on other attributes is as valid a concern when you look at harm. None of them have the same historical antecedents in human rights law that race has, and that does tend to raise some concern. So I'm on easier ground talking about race because fewer people are going to debate me. It will be different if we start talking about sexuality and vilification.
Hi, thanks for that. I'm Deb Chapman. We're here from Reconciliation Victoria, and we're involved in constitutional recognition campaign and referendum, and it must be said a significant number of Aboriginal people that we are working in Victoria are rightly, well, sceptical about this conundrum, the direct opposition between changes that bring to the Racial Discrimination Act and what's proposed for referendum changes. Any reflections you think about?
I've got a group of really impressive students that I work with at ANU who have established a group called Ready for Recognition, working with the various constitutional campaigns. And they set about a couple of years ago their own project to promote understanding of the changes so as to facilitate them. And they're going through a crisis at the moment because they are aware of the significant view in the Indigenous community that perhaps constitutional recognition isn't the right thing to do, or the terms that are proposed the right thing to do. And having been earnestly enthusiastic for this, they find that the very people for whom they thought they were working are in fact great. So I don't know the answer. I know it has become a much more difficult question now than it was when we all thought it was a great idea 3 or 4 years ago. And my practice is always to defer to what I unfairly call the Indigenous view, but of course that's in which case what I'm deferring to is whatever the Indigenous community can work out for themselves on what his position should be. And until then, I say to my students, look, it's still important that people understand what the Constitution says, and it's still important they understand that it could say something different and perhaps should, but precisely what it should say and whether the Indigenous people of Australia think that's what it should say is a debate.
What this proposed change is actually signalling to us.
Yes, yeah, and I think that's one of the realisations that we thought we'll put the words in there, and a bit like what I was saying, we feel better about doing that, but no, the implications are very significant, and it's probably appropriate we recognise that the Constitution has symbolic implications.
And not much leadership in that area.
None at all.
John Carmo from Deakin Law School. In your introductory remarks, you spoke about law and education. Now, I can remember as a great enthusiast when law started coming in from 75, thinking, oh, this is going to lead to education and change and so forth. So the law and education are marching hand in step. Now, social psychologists tell us that attitude of change is about one of the hardest things to achieve. Do you think that some of that earlier hope is showing its limits in this particular area? Has it failed or plateaued or what? And how it just finally, how important are things like vicarious liability being, at least in terms of workplace vilification, in terms of employer duties to educate going forward?
I don't know how long we wait before we say an effort for change has failed. Particularly when we're talking about attitudinal change. And yes, all the high hopes of discrimination laws generally have been shown to have been naive when we realise how entrenched other values are. Look, I do have a bit of a thing about public leadership and a bit of a conviction that we don't get places unless we're shown where to go and how to get there. You wouldn't have a charter in Victoria if Rob Holt hadn't decided to do it, for better or worse. Some people will condemn him for it, others will praise him for it, but I teach law reform, and it's really interesting how quickly the students, when going through case studies, see for themselves the fact that change is so often referable to somebody who made it happen, somebody with the courage or stupidity to run with it. Anti-discrimination law has not had that kind of leadership. We haven't had a government since Michael Lavarche introduced the racial qualification provisions, who believe in it, who will make a stand on it. The consolidation that wasn't introduced by the Parliament, by the Labor government, was the next big step in discrimination law, and we couldn't get anybody to care. So I think that if we acknowledge that hopes for law bringing about change may even, you have to do a lot more that's conscious, deliberate policy. You've got to reinforce and follow through across the whole range. That needs somebody to make it happen. That needs some kind of coordinated leadership. And it's really unfair to expect the Australian Human Rights Commission to do all by itself. But that seems to be where we park it. So the short story is, yes, I hesitate to say it's failed. I think what we've realised is that much more is needed. I am consistently critical of anti-discrimination laws and vilification laws for the way they operate and the failed promise. On the other hand, I wouldn't give them up. I think it's really important for the world to know we have them, even if they fail us and frustrate us. And the fact is they are a statement, and it would be unimaginable that we would ever say, well, they don't work, let's stop using them. So we can't repeal them, we can improve them, but for as long as they're there, I think they're an important symbolic statement, which make a difference. I think the reason why outside no one's going to walk up to you and say, walk up, not to me, no one has any, some of you may have seen me say on television, I honestly feel I can't be insulted. I tick every box of, straight down the middle, white, middle class, male, heterosexual, you name it. But the reason why others aren't abused to their face as much these days is because we have discrimination laws, because we know that that's the message. It's the underlying stuff that is still out of reach.